My presentation is on justice from the accused person's lens. And I would actually like to quote sections of the articles from the Constitution. The very first one that deals with the access to justice to accused persons will be Article 58 of the Constitution, that actually acknowledges the fact that arrested persons also have rights, just like any other normal citizen, apart from some few rights that will actually be taken away by virtue of the fact that they're actually either incarcerated, detained, or serving some term in prison. But then also, we are also informed under the same Article 49 that an arrested person has to be informed of the reason for arrest. The person has to also be informed of the right to remain silent, as probably anything he or she does or says may actually be used as evidence against them. The accused person or the arrested person also has a right to an advocate. The accused person or arrested person has a right not to be compelled to make confessions or admissions. And if this so happens, then the person is actually supposed to be informed by the advocate later or a paralegal that it isn't right, and he can actually have it fixed when he finally appears before a magistrate. The other issue that an arrested person needs to understand is that they're actually supposed to be placed separately from people who are serving a sentence, assuming that the person was not able to raise bail or bond. Another thing that an accused person or arrested person has to understand is that he or she has a right to bond or bail. And if at all, maybe on the very first instance, after taking plea, the bail terms are actually a bit high, and maybe he or she is not able to raise them, he can make an application in court at a later date for the same to actually be reviewed downwards. The other thing is that an accused person or arrested person has a right not to be remanded for an offense that, if at all he or she will be convicted, he is going to serve a sentence of 6 months or below, or a fine, or an offense that is only punishable by a fine. The other thing that we need to understand is it falls under Article 50 that talks about fair hearing. We need to understand that an accused person or an arrested person has a right to a fair trial. A fair trial will actually be talking about the trial, or the period that this particular trial takes is actually supposed to be timely. It's not supposed to be delayed unnecessarily. It's actually supposed to be heard in short within a reasonable time period. As I mentioned earlier, the accused person or an arrested person has also a right to an advocate. We may need to understand that initially the state only used to provide for advocates to suspected persons who have committed murder. But then at present, as we speak, even an accused person who has been charged for the offense of robbery with violence, which can also attract a life imprisonment or a death sentence, even though the same is not being meted at the moment as we speak, has actually a right to be accorded an advocate at the state's expense. The arrested person also has a right to statements, an interpreter, whom he or she is supposed to get without payment of any fee. The other thing that we need to understand is that an accused person has a right not to be convicted for an act or omission that is not an offense in Kenya or a crime under the international law. By this, what I mean is that there could be certain acts or omissions that are actually constitute to become an offense in our country, but not in a different country, or could constitute an offense in a different country, but may not necessarily be an offense in our country. And so it's supposed to be very clear that you cannot be charged for an offense that is for an act or omission that doesn't constitute to be referred to as an offense in our own country. A good example will be in some countries, for example, you may find that possession or smoking of marijuana or bhang is not an offense. To them, they would set aside some special cafes or certain areas set aside for such a purpose, for smoking or for selling. But then when you come to Kenya, that's a punishable offense by law. Another thing that we are supposed to understand is that an arrested person or an accused person has a right not to be tried for an offense that he had actually been acquitted upon or convicted of. By this I mean, if an accused person had been charged for a particular offense, and then it happens that at the end of the trial, the accused person ends up being acquitted or convicted of that particular offense, then the same cannot be brought back later after either a conviction or an acquittal had been arrived at. The other thing that we need to understand is that the right to appeal is never taken away. So any given accused person has a right to appeal a decision of the court that was actually trying him or her, and also to a review of the same sentence, assuming that the person was actually convicted of under a particular sentence set for him or her to serve. But then whenever you're making an appeal in that particular instance, then you'll only make it to a higher court than the one that actually sentenced you. Another thing is that an arrested person has a right for a retrial. A retrial means that maybe a particular case had been had and probably even determined. But then, just in case some new evidence comes up, then the accused person has a right to petition the High Court to have this particular case retried, meaning that we begin from the onset, whereby all the witnesses who had testified before are actually brought in afresh to testify afresh, and the accused person is actually allowed to cross-examine these particular witnesses. We then also need to move to, there's another very important article, Article 50, Sub-Article 7 of the Constitution, that talks about an intermediary. An intermediary is someone who may not necessarily be an advocate or a lawyer for that matter, but someone who actually has an understanding of the issues that an accused person could be having, or has some little understanding of this particular act or omission, or has an understanding of the problem that this accused person could be having, or even a complaint for that matter. So what the intermediary does is to assist the court on behalf of this particular accused person or complainant to communicate with the court. This one will find it under Article 50, Sub-Article 7 of the Constitution. Then when you move on, Article 51 of the Constitution simply just talks about the right of an accused person, and especially under the Bill of Rights. In simple terms, an accused person is entitled to all the rights under the Bill of Rights, except those that are occasioned by the fact that he or she is detained, held in custody, or imprisoned. I would like to also venture into some of the challenges that an accused person normally has by virtue of the fact that he or she has been detained or held in custody. And one of them that is a very major one is lack of representation. And this one happens due to the fact that majority of those who are in remand especially are not able to afford the fees or the levies that are charged by the advocates. Another issue is overcrowding, which actually is a big concern because our facilities are actually holding way above the number of prisoners or inmates or remanded prisoners that it was actually meant to hold. This one, if we look at it critically, one thing that we need to really bear in mind, because it has side effects. For example, overcrowding may cause communicable ailments and so on and so forth. It may also cause the existence of poor living conditions, as stated above, which may also bring about treatment issues. Remember, the prison facilities that we are having, some of them do not really have fully fledged health facilities, and so most of them actually rely on making referrals to other government facilities that are around. Overcrowding may also bring in the issue of poor food rations, which we all understand. Another thing that is a challenge to prisoners whenever they're in custody is, in some instances, they normally receive abuses from officers or even fellow inmates, having to bear with the long periods taken to hear and determine their cases as a result of poor legal literacy levels that they have. A majority of them are not even legally literate, and so they have to depend on either the paralegals or the lawyers who may want to like take up their matters pro bono. The other issue that is actually a main cause of the lengthy period that these particular prisoners take for their matters to be heard and determined in prison while in custody is misplacement of police and court files. The unavailability of witnesses due to them not having been bonded on time, lack of transport, for example, but this one is on the side of the witnesses because some of them may lack money to enable them move from their homes to court for purposes of giving testimony, and so on and so forth. Another issue that could actually cause the lengthy periods that the prisoners take for their matters to be heard and determined would be the absence of a magistrate for one reason or another. Maybe the magistrate hearing this particular matter could be attending a meeting or any other official duty, making it so hard for the matter to continue in his or her court. This actually prompts the duty court to simply just allocate other future dates for this particular matter to be brought back to court again. The lack of other court officials, including the prosecution and the court clerks, would also be a hindrance and actually end up causing a particular criminal matter to take a longer period in court than expected. Our last one that I would like to talk about here and now would be the huge or unaffordable bail terms meted on these particular prisoners, which they are not able to raise. These ones actually may cause them to stay longer in custody. And remember, some of these matters, some of these prisoners actually even spend years while in remand before their matters are actually heard and determined. Remember, it's not a must that if you spend longer in prison, like for example 2 or 3 years in remand, that now you've actually served a sentence. It's upon the court now to probably like consider the fact that you had spent a longer period in remand custody, and probably if you're having a good day with the magistrate, they could like deduct some of the sentence period and probably like have you serve a lesser term by simply just bearing in mind that you served a period while in remand custody. What is the cure for all these challenges that I've raised above? I believe paralegals have been doing quite a huge chunk of work. Remember, in a number of our facilities, prison facilities, we are having paralegal officers who've been seconded there to work therein by other civil society organizations. We've also had other organizations who have ended up training prison officers as paralegals. And these ones, the two have actually helped these particular prisoners to really understand the basics in matters law. The paralegals have also been doing follow-ups media to the relatives to these particular accused persons, ranging from just informing them that your relative or friend or employee is actually in a particular facility. The bail terms are these. Are you able to like help the person to in any given way, like in terms of raising the bail terms, or even getting a lawyer for this particular individual who has been charged for a particular offense? We also do referrals to the advocates and so on and so forth. Another cure to some of these challenges will be through engagements while operating within the court users committees, otherwise known as CUCs, to discuss and address pertinent issues that affect the prisoners plus any other given actor within the criminal justice system. Something else that I would like to touch on would be there are normally other decongestion practices carried about by the judicial system in conjunction with the probation and the children's departments, as well as application for reviews by the prisoners. As I terminate, I would like to talk about what I've been doing for the last 3 years as a paralegal and diversion officer. Mine has been simply to just divert children matters. Our belief and my belief in person has been that children are actually not supposed to be incarcerated or institutionalized for that particular matter. Our belief has been that children are actually supposed to be more at home than in institutions, because the institutions actually do not understand much to do with the children's growth and development. And in so doing, they could actually end up being a hindrance, and a very big hindrance towards the upbringing of these particular children in matters of education, as well as in other welfare-related issues. I've also been doing plea bargaining, as well as encouraging the application of restorative justice as other forms of alternative dispute resolution when handling these children matters. I hope I've tried to capture all that you wanted. I'm Allan Odhiambo, paralegal and diversion officer. I'm based in Mombasa.